But some of the different skill sets involved are selecting and synthesizing rules, interpreting statutes or contracts, which in a way is a type of identifying the rules that apply to a given situation. But a syllogism is a three-term argument where you have a major premise, minor premise, and conclusion. So the major premise is, in the case of legal arguments, is a rule statement, conclusion plus reasons. So in other words, you state your desired legal conclusion, and then you provide reasons, sufficient reasons to support it. And they may be, perhaps each reason is sufficient in itself.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Ryan McCarl. Ryan McCarl is the author of Elegant Legal Writing, published this year, 2024, as well as the blog elegantlegalwriting.com. He is founding partner of the business litigation firm Ryan McCarl, LLP. He has taught advanced legal writing courses at the UCLA School of Law, as well as the LMU Loyola Law School, and given talks about the appellate advocacy and litigation strategy to audiences, including the ABA litigation section and the Texas office of the Attorney General. The webinar presentation that you're about to watch will be approximately 1 hour, and once the presentation is complete, Ryan will be taking questions from the audience. If you have any questions that come up during the presentation, please feel free to submit them through the Q&A button in the control panel at the bottom of your screen, and those will be addressed at the end of the presentation. Without further ado, here is Ryan to discuss logic for lawyers, crafting persuasive legal arguments.
Thank you, Nina. I'm going to go ahead and start my presentation here. So I appreciate you, Justia, for having me, and I look forward to talking to all of you. I'm glad you were able to join us. So today I'm going to talk about logic for lawyers and crafting persuasive legal arguments. We're going to cover a couple different items. The main problem that triggers the need to discuss legal reasoning, which is the habit lawyers and law students have of often using conclusory reasoning. And we're going to talk about a traditional model of legal syllogisms, and then the role of procedure in making arguments. And then the sort of mantra that I use, conclusions plus reasons, and I'll explain what I mean by that, and then talk about how to design good arguments. So I appreciate, we've all heard the introduction, so I'll skip over this part. I'll just note that my book, Elegant Legal Writing, has about 3 chapters in the middle on about the substance of legal argument. So it discusses conclusory reasoning, it discusses how to select and use cases effectively, and how to craft compelling fact narratives. But to get the book under the word count, I had to take out 2 additional chapters about legal reasoning. So it's become the seeds of my next project. And most of what I'm going to discuss today relates to that next project. So it's kind of new material. I've been intensively researching legal reasoning and argumentation for the past year or so, in addition to casually before that point, and starting to gradually synthesize what I'm learning from the many people who have tackled this subject before. And as with Elegant Legal Writing itself, I think 90% of the ground has been covered. There's little new under the sun when it comes to logic and argumentation, which has been discussed since Aristotle, at least. As with writing, which has been discussed since Aristotle, at least. But that said, there's always ways to kind of combine past approaches, teach them in a new way that maybe clarifies principles that escaped us earlier, show them by examples, and kind of add my own spin to it as well. So I'll start by saying that legal reasoning is multifaceted, and it's impossible to cover the vast majority of it, much less in a book, maybe even much less in a 60-minute presentation. But I just want to sort of alert you to what I see as being some of the core skills that good lawyers engage in when they're designing arguments and writing briefs. And I would note that these are not really captured very well by traditional frameworks like IRAC and CREAC, the formulas that people are taught to write with in law school. Often such as issue, rule, application, and conclusion, or conclusion, rule explanation, application of the rule, and then conclusion. those I'm not a big fan of those frameworks. And the chapter on that point has gotten some attention in my book. I'm probably not going to go too much into depth into them today. Rather, I'll just kind of move on to discussing alternative paradigms that I think are more helpful. But some of the different skill sets involved are selecting and synthesizing rules, interpreting statutes or contracts, which in a way is a type of identifying the rules that apply to a given situation, making and parrying argument moves from the simplest ones of challenging an opponent's precedents to attacking the credibility of their evidence, attacking claiming that an issue's already been decided. There are many such moves in the law that I'll allude to a little bit later. And selecting and characterizing material facts, which are facts that kind of intersect with the rule, and that you're trying to apply, and that hopefully are sufficient or not sufficient to establish that the rule applies in a given case. Making and challenging inferences, weaving together rules and facts, mutually characterizing the rule to fit the facts, and characterizing the facts to fit the rule. Obviously, to be persuasive, it needs to be a sort of a weaving that's consistent with the authorities and that's intellectually honest and that isn't trying to sort of tweak or embellish the available facts. But at the same time, this is what lawyers often will be doing, which you don't just take the rule and the facts and juxtapose them side by side. You weave them together to show how these facts fit within certain precedent or don't. Telling coherent stories. So some stories are plausible because they accord with our understanding of how human beings normally behave. Some are not, and so this is when preparing for a jury trial. Like I'm doing with my firm, Ryan McCarl LLP. We've got 2 upcoming trials, and a lot of that preparation involves taking the elements that we need to prove on the plaintiff side in this instance, and mapping that onto a story that is going to resonate with jurors because based on their kind of common stock store of human experience, it all is going to strike them as plausible. It's going to make sense. It'll be consistent with their notions of how people are. And of course, quite a bit of legal argument involves using legal authority. We don't use logic as much. We don't use sort of purely logical arguments as much. It's not like an op-ed. Pure rhetorical moves that are kind of unrooted from authority are just not very effective. So a great deal of the nuances of great legal writing is appropriately using the stock of legal rules that's available in precedents, such as cases and statutes, treatises, and then private law, such as contracts. And then finally, integrating appeals to policies and values. These cannot by themselves override binding rules, but oftentimes they can be used to argue that one rule applies and not another, or that a rule applies in a certain way and not a different way. And also, using the rhetorical concept of pathos, making the decision maker feel good about the decision because it accords with a particular policy. So the reason that that makes it so urgently necessary to think about legal reasoning, if you're a lawyer or a law student, is that it's just so sometimes our view of a case gets so rooted in our in our being that we forget that there's other ways to see the case and the case's facts and legal arguments, or we start to see things as self-evident, and so we forget to make sure that we elucidate our premises and really look at our arguments from a skeptical perspective about how they might be challenged by opposing counsel or a skeptical judge. So the most common mistake that law students make and that practicing lawyers make as well is what lawyers call conclusory reasoning, which essentially is not reasoning at all. It's just asserting your conclusion without specifying reasons to accept the conclusion or without adequately identifying and supporting contested premises. So the general rule of thumb, and really the most important concept that everybody should learn in law school and remind themselves at all times when they're writing, is that if a statement is disputable, if there's grounds to conceivably dispute it, then it should be defended. And it'd be defended by legally cognizable reasons, such as citations to binding authority. There are many varieties of conclusory statements, and I talk about some in the book, and I'll just run through a few examples now to sort of maybe catch yourself. Maybe if you see some examples, you'll start to see you'll start to catch more examples of conclusory reasoning that makes it into your own drafts, and realize that maybe there's a need to back certain statements that yet you didn't do the first time around and can improve in a revision. So there's, of course, the familiar bare legal conclusion, such as the defendant's liable because they breached the contract. It's called begging the question in philosophy. It's not an argument. So an acceptable version might be that defendant failed to deliver the goods as stipulated in the agreement. So you're adding the facts that show the legal conclusion and compel the legal conclusion to be reached without just asserting that the legal conclusion applies. A lot of students, especially, I think I partially blame the CREAC model for this, but a lot of law students and lawyers over rely on rule statements, which are not complete reasons to support any argument because they always have to be intertwined with facts. So you'll often see something like this, like these next two examples, where you have kind of a dwelling on the rule statement or repetition of the rule, kind of masquerading as an argument. So first example is, because the Fourth Amendment bars the police use of excessive force, the arrest violated defendant's constitutional rights. Again, it just assumes the conclusion without defending it. And it also is stated at such a high level of generality that it's untethered from the specific facts. It just essentially repeats the rule statement. So an acceptable alternative might be, the police used excessive force by striking the defendant while he was restrained and posed no threat to the officer's safety. Then you'd probably follow that with an analogous case that supports the proposition that striking a restrained arrestee is excessive force under the Fourth Amendment. Another variety is to list elements plus a conclusion, pretty similar to the previous example. For example, defendant is liable for negligence because he fell short of the duty of reasonable care and, as a result, injured the plaintiff. The elements of negligence are duty, breach, causation, and harm, and all that sentence does is assert that they are met in a case. Again, it's not an argument. So a better example might be something like, defendant is liable for negligence because he failed to repair the hazardous staircase that collapsed under the plaintiff. Again, so you'll notice that in each instance, it's the addition of specific facts and that speak directly to the elements of the rule that is the essence of legal argument, and that step can't be skipped. A couple more examples. You have what's called an intensifier or intensifying adverb, statements like clearly or utterly, or maybe even indisputably, black letter law, all sorts of statements that we have. We have a whole lexicon of them because this is so tempting to do when we argue. We just, things seem so, we actually so often believe that something seems so self-evident, surely it doesn't require explanation. But in fact, we have on the other side oftentimes a capable opponent who is capable of challenging it, and that's their job. And they may do it effectively, especially if we don't adequately argue for our own premises. So an intensifying adverb like clearly cannot by itself, it can never provide any kind of backing. It's not a reason. It's just kind of a banging of the table. And in fact, it often, as I discuss in the book, arouses skepticism in the reader and makes a statement less convincing because opposing counsels and judges and even jurors are skeptical listeners or readers. And it's their job to filter what you're saying to test its truth and test its accuracy and reasonableness. And given that that's the posture that they're in, they're not inclined to just take your word for it because you say clearly, for example. So as an example, the agreement is indisputably enforceable. Doesn't add anything to your argument. And an alternative might be, The agreement's enforceable because it satisfies the requirements of UCC Article 9. And then you pick the contested or disputable elements of Article 9 in this case, and then defend them. Legal conclusion masquerading as fact. So, for example, plaintiff's recovery is barred because she had the last clear chance to avoid the accident. Last clear chance is a legal term of art that you have to defend before just asserting that it applies. So, an alternative might be plaintiff could have avoided the accident by swerving or braking, but was too busy looking at her phone. Legal characterizations masquerading as facts, similar to the row above. Defendant unlawfully accessed the secure servers and downloaded plaintiff's proprietary information. And an alternative might be defendant found Jones' password and used it to log in to the company's intranet, and he then downloaded plaintiff's customer list. So it's adding factual specificity once again that's tied to that essentially fills in those legal characterizations or supplies the information for the reader to understand that the rule condition is met. And then finally, the last one, we have unintelligibly vague allegations, such as plaintiff downloaded defendant's artificial intelligence and predictive analytics, which are trade secrets. Trade secrets is a term of art. If this is a trade secret case, then we have, again, assuming the conclusion that you're trying to prove. But also you have this other component of this example, which is what on earth is meant by the terms artificial intelligence and predictive analytics. I'm sure you've all experienced a lot of marketing across the internet in the legal tech world and in the world more generally, where everybody wants to say now that their software includes AI. But what's interesting is that they've been saying that oftentimes for maybe 20 years. And only recently have you had the big revolution in AI with ChatGPT and the other LLMs. In a courtroom, a statement that a company's lawyer's statement that their software uses artificial intelligence just doesn't get you very far, and it doesn't have a lot of content to it. So an alternative might be plaintiff downloaded defendant's patent protected software, allowing dealerships to predict when a customer might buy a car. So a traditional way of thinking about legal reasoning that I'll address and that I initially taught when back when I first started teaching legal writing courses, this one at UCLA Law in 2020. What is this idea of a legal syllogism? So a syllogism is kind of the core move in deductive logic. And it's when you think about IRAC and CREAC, they're really kind of variations on syllogisms. But a syllogism is a three-term argument where you have a major premise, minor premise, and conclusion. So the major premise is, in the case of the legal arguments, is a rule statement, a statement of law. Minor premise is the fact statement that you claim brings the fact or falls within the rule. And then the conclusion is that the fact falls within the rule, essentially. Even as I just described that, you can kind of hear that the thing about syllogisms is they don't actually really add any information that's already not contained in their premises. They're also at a pretty high level of argument, as we'll talk about in a couple of minutes. So they may be self-sufficient in cases that are very simple. Like I always use as the simplest example of a legal problem, a speeding ticket. Major premise is the speed limit is 55 miles an hour. Minor premise, defendant was traveling 70 miles an hour. And then you have an implicit premise that doesn't need to be stated, which is 70 is greater than 55. And then you put the major premise and minor premise together, and voila, you have the conclusion: the defendant violated the speed limit. And that's a totally sound argument. And in fact, that's all it takes. That's why we have automated speeding ticket machines in some states, because the robot knows it measured your speed as you went by, and as long as the sensors are correct, it knows the speed limit, you don't really have an argument. So unfortunately, that's not how almost any contested issue in civil litigation works. The syllogism turns out to be a too high a level of generality. So if it makes an appearance, it would make an appearance kind of as the sort of the last step before a conclusion, but it shouldn't be mistaken as a self-sufficient argument in most cases. The reason is that the real nub of legal argumentation usually occurs in arguing about the premises. So what is the rule really? How do we understand? How are we to interpret this rule in situations like this one? And then what are these facts? And even if the facts are even agreed upon theoretically, as in uh, when you're on appeal and there's been findings that aren't challenged, there's usually a way to characterize the facts as falling within the rule or not. So once again, you have that mutual adjustment of those premises, but the premises themselves are going to be attacked. So therefore, they need to be defended, and the syllogism by itself doesn't tell you how to do that. So here's an example of a syllogism that maybe is superficially appealing, but not a convincing argument, hence my emoji choice. So major premise, battery requires proof of intent to cause harmful or offensive contact. Minor premise, the baseball player didn't intend to hit a fan when he threw his bat into the stands after being ejected. Leave the conclusion clearly, the player isn't liable for battery. And of course, if you're arguing against this, then you would challenge these premises. For the first one, that is true. Battery requires proof of intent to cause harmful or offensive contact, but that particular rule statement, I would argue, is at too high a level of generality to address this particular case. So, and then the minor premise, didn't intend to hit a fan. You have there, to some degree, this idea of equivocation, where you slip out of the discourse of legal terms and into sort of everyday, more casual language. So it's kind of like, I didn't mean to, like a toddler might say when they hit somebody. Well, that's not exactly the same thing as legal intent. Legal intent is a term of art that has goes back centuries. That's the meaning of it varies by context. So in fact, the relevant intent will be imputed to this baseball player, because so long as the stands are full of fans, and it's reasonably certain or that if he throws a baseball bat into the stands, it will hit somebody. So that'll be held to be constructive intent. So you can challenge these premises, challenge how they interact, and then you find that this superficially appealing argument collapses. One of my one aspect of the way legal reasoning is often taught with IRAC and CREAC and so on, is that we often overlook procedure. And I think one of the reasons my book has resonated with a lot of practitioners is that I am one. So like many of you, I was up late writing filings. I'm preparing for trial. And I think when you're in the trenches doing that, you have maybe a little bit more heightened awareness of how much procedure matters. And if there are any law students or new lawyers listening, I can tell you that one of the ways that you can make yourself the most useful to a litigation team is to just become fluent in the relevant rules, the court rules, the judge's rules, the civil procedure rules for your forum, and the evidence rules and so on. If you are an encyclopedia of rules who immediately knows which one applies in a given situation, it's going to be hard to get rid of you because you'll be so useful. So how does procedure affect legal reasoning? And I'm going to explain here in the next couple slides. So litigation arguments are shaped by their procedural contexts. So everything that we just discussed in terms of legal syllogisms was all about substance. It was all about whether the elements of battery were met or the elements of a speeding ticket are established. So, but both of those examples are abstracted from any kind of procedure, and that is how, that's how IRAC often is done. When you teach legal writing courses, there's often sort of a set of facts that is taken as given because there's not going to be any kind of evidentiary workups. The facts aren't usually given in that way, and the available facts are rarely, are going to vary based on the motion in each instance and based on the particular case's state, based on findings that have occurred, admissions that have occurred, and so on. So really, the set of available tools that you have to argue with changes with each procedural step in a litigation. So some of the facts, some of the procedural aspects that affect making what arguments are effective are the case state, like I just said, default rules, which means what happens if nothing happens? What is this? Who wins? The tiebreaker goes to whom? For example, a default in civil litigation occurs when one side doesn't show up, but if the suit doesn't occur, then the default rule, the status quo, is going to be that wherever the particular rights or money are held right now, whoever's bearing the relevant costs is going to continue to do so. So when a plaintiff files a suit, they're trying to switch that, move away from that default. And every motion is essentially an attempt. Almost always the moving party has an obligation is the one with the burden to show an entitlement to relief. So they're attempting to move the procedure off of the default that would apply if the motion was never filed, and they're trying to change the case state going forward. And then, as I alluded to a moment ago, depending on the procedural posture of a motion, you may face evidentiary constraints and constraints about which law applies. So I've come across in my studies of legal reasoning some terms such as current fact situation or argument situation that try to capture kind of the set of available premises, factual premises, and legal premises, and kind of put them on the table as what you can use to craft an argument. And I find those kind of terms to be pretty unwieldy. So I've started using the term bout to sort of visualize the procedural the procedural and substantive combined situation that occurs when you fight over a motion in civil litigation. So best to explain by example here. So, for example, a defendant moves to dismiss under Federal Rule of Civil Procedure 12b-6, which is as a tool to say that even if everything in the complaint is true, the plaintiff doesn't have any legal remedy. So there's these different variables that we talked about. Here's what they look like in this situation. You have the case state. This is usually early in the litigation where there haven't been significant rulings, no facts have been found. So your universe of facts is going to be the facts that are alleged in a complaint or are sort of objectively verifiable by the judge and therefore may be subject to judicial notice. For example, statements in an opponent's pleading. Available rules. The actual 12b-6 standard doesn't shed any light on how to apply it. So you have the general Supreme Court on down precedents of how this rule operates in practice in a more granular way. For example, legal conclusions are not treated as facts. That must be assumed true. The facts alleged must be plausible to be assumed true, and so on. And then at a more granular level, when you're selecting which cases to argue about, the further afield you get from cases that are decided in this context of challenging a pleading, the more risk you run of selecting something that turns out not to apply. So if it's out, you always want to find authority that is decided in a similar procedural posture or one that's even less favorable to your side. Otherwise, it can be pretty easy to distinguish. Then you have the default rule and tiebreaker. So who wins if nothing happens? And the answer is that the defendant filing the motion to dismiss loses, and the plaintiff is allowed to proceed. And that is, in fact, how most motions to dismiss turn out. So, and then finally, who has the burden and what's the relevant standard? Again, the defendant has the burden, and what they're required showing is that the facts plausibly alleged, if true, wouldn't entitle a plaintiff to relief under any theory. And what I want to emphasize here is that these variables constrain the legal argument, and by constraining the available premises and the available arguments. So whenever we talk about legal syllogism or other models for arguing about substance, it all occurs in practical litigation within a procedural game or bout like this. I've started using as my mantra. I criticize IRAC and CREAC for many reasons, and of course, people want to know what's an alternative. Well, my simple mantra that I teach is conclusion plus reasons. So in other words, you state your desired conclusion, and then you provide reasons, sufficient reasons to support it. And they may be perhaps each reason is sufficient in itself. So if these are fallback arguments. If one fails, we have another one and then another one, or perhaps they jointly work together to strengthen an inference that the conclusion is true. We're going to talk more about how to design these reasons and select them and flesh this idea out a little bit more. But the idea of starting with a conclusion and then backing it with legally cognizable reasons is really the key move in writing effective arguments. Most premises are linked. So this goes back to the examples of the examples that I talked about of conclusory statements in which you have a rule and then a conclusion. The rule statement by itself, just like a discussion of a case by itself, is not going to be a reason because it has to be intertwined with the facts of the case. So the rule and the facts operate as joint premises, both of which you need to create a reason. Here's a diagram explaining, kind of showing how this works in practice. So suppose that in a personal injury case, the plaintiff needs to prove that somebody ran a red light, the defendant ran a red light. So there's two linked premises. You bring a witness, put a witness on the stand to testify to that effect. The witness testifies that the defendant ran the red light. And there's another premise that may need to be established, almost certainly does, and this is what lawyers call foundation, is that the witness was in a position to observe whether they ran the red light. If they were out of town, not much weight's going to be put on their assertion that the defendant ran the red light. And then there's an inference pattern from it's called argument from a position to know. The witness was in a position to know whether the defendant ran the red light, and the witness says that is what happened. So presumably that is what happened. Presumably the witness testimony kind of puts a stone on the scale, making it more probable that is what in fact what happened, and it's going to have the effect of sort of shifting the tactical burden or the temporary burden to the defendant to put up their own witnesses or otherwise challenge this testimony. And one way they can do so is by challenging the inference itself by bringing in additional information. For example, I have here at the bottom of the chart, witness is blind. This is called an undercutter. It undermines the inference from the premises to the conclusion. So the couple key ideas here as well. So you have, I'll just mention one. I think the others I've made clear enough. But with defeasibility, the one of the problems with importing the model of syllogisms to the law is that in deductive logic, where the concept of a syllogism originated and exists, there's sort of a certainty to it. So the idea is that you take the premises as true, and therefore it follows as a matter of logical necessity that the conclusion occurs. But that's just not how it works in almost any legal situation. All that you get in most legal arguments is a increased probability of the truth of the conclusion, or you may get sort of a burden of production being met, as in this instance when you put the witness up and they testify as such, and that's presumably the outcome. However, the conclusion is defeasible, meaning that there may be other ways that the defense can challenge that conclusion by putting on other witnesses who say the opposite, for example. So rarely are conclusions fixed in the law. They usually they're usually subject to challenge and only provisionally held. Some of the steps when you're crafting a legal argument that involves, if you want to sort of break it out into particular, more granular steps, is that you obviously start with the conclusion that you want, which is that your client wins. If you don't see you don't see any way to reach that conclusion, time to settle or decline the case at the intake stage. But assuming that your client has a path to victory, then that's your conclusion that you're trying to reach as an advocate. And then you're going to devise legally cognizable reasons, usually are almost always backed by citations to authority. And then you'll kind of rank those reasons by strength. And by strength, I really mean which of these is most likely to persuade the judge or fact finder to rule in my client's favor. And then you have to identify how to establish each reason, because each reason is going to have premises, usually facts plus law. How do you establish them? And then you're going to want to support the legal premises with apt authority, and the fact premises with admissible evidence that's also credible. And finally, you then structure the resulting pattern into a coherent, easy to follow argument. So the next thing we'll talk about is how to do that last step. Okay, so this is an argument map that I put together. It is intended to kind of show what this looks like in operation in terms of devising reasons and thinking about this concept of linked premises that I talked about. So at the top of the chart, this is the situation here is a securities fraud case and the element of scienter, which is essentially intent to defraud. So the question is, the conclusion that you're trying to reach as the defense attorney challenging this element is that there was no intent to defraud. So you have to then marshal reasons for that conclusion that you want. And in this case, I have one reason that adds up to that conclusion. And it looks like there are many premises, but they all add up to one reason in a way we'll see. So just working downward from the conclusion, the next row, you have a sort of factual conclusion or intermediate factual conclusion that we'll call the defendant Dennis had the same incentives as the investors. Standing by itself, untethered from a legal rule, it doesn't function as a reason because it doesn't directly speak to whether the element of scienter is met. So it needs to be tied to a rule that shows that incentives, in alignment of incentives between the plaintiff and the defendant has a bearing on this element of intent. So to the right, you have the same incentives rule. So the rule of law is if an investment promoter has the same incentives as the investors that they solicit, then they probably don't intend to defraud the investors. So once you combine that rule with the intermediate factual conclusion that Dennis had the same incentives, now those together function as linked premises that operate together to as a reason that the scienter element is not met. Then each of those linked premises will itself likely be challenged, and so that needs to be backed and defended. Some premises are going to go without saying and can sometimes be left implicit, but most premises are going to be challenged most of the time, at least the significant ones. So the same incentives. How do you establish this intermediate factual conclusion that Dennis had the same incentives as the investors? And there's for this one, you have two independent reasons supporting that intermediate conclusion. One, in his capacity as an employee, Dennis made money only if the investor made money first. Investor has to get paid first for Dennis to make money. That makes their incentives aligned. And then the second box over on the bottom row, in his capacity as an investor, Dennis stood to gain or lose his invested funds, depending on whether the investment succeeded. So therefore, he had the same incentives as the investors, which was to see the investment succeed and for everybody to make money. So those are what the trial lawyer does is put on evidence supporting those bottom line factual conclusions, and then usually in the closing argument or hopefully earlier as you go through the case presentation, you help the jury kind of go up this chain of inferences from the facts that you're establishing through your evidence to intermediate factual conclusions, and then finally it's going to get tied into a legal conclusion in the closing argument or earlier, and that legal conclusion should align with the jury instructions and verdict forms. That's the fact side on the left side of this chart. On the right side, you need to defend this legal rule that similar incentives to an investor, if the defendant has similar incentives to the investors, then it tends to show that there's no intent or scienter. There, how do you defend a legal rule? The best way, almost always, is to point to a binding statute, a binding contract, or a binding case. and the case should be decided in a similar procedural context. The facts should be analogous. The claim should be the same in most instances. So, for example, we have here in the bottom right box a Ninth Circuit case called Worlds of Wonder Securities Litigation, and a parenthetical saying that the case held that officers of a company had conclusively negated any inference of scienter when they held on to most of their stock and incurred the same large losses as did the plaintiffs themselves. So that language doesn't say anything about incentives by itself. So this is where the legal researcher and analyst skill comes in, of being able to abstract from that fact situation into a general principle, such as this incentives rule, formulate that rule in a way that it can accurately be backed by the case, and then weave it in with the facts. So that's kind of how I think about legal arguments in a nutshell. The core of it. There is also another sort of layer that's helpful in thinking about legal arguments, called argumentation schemes or argument schemes. And I learned about these from a pioneer in informal logic and argumentation, who's also written about legal reasoning. A person named Douglas Walton, who was a Canadian logician, passed away not too long ago. And this book, Argumentation Schemes, is quite good. It's a dense read, but in my book that I'm working on, my next book, I'm going to share some examples of the concept and kind of try to boil it down to its essence for legal practitioners. But argument schemes are essentially inference patterns, oftentimes implicit in arguments. And so what Douglas Walton and his colleagues did is to sort of abstract out from many different arguments into sort of generalized argument paradigms. An example familiar to trial lawyers will be arguments from expert opinion. So essentially, the argument from an expert opinion looks like this. You say that your witness is an expert in a certain domain, and the witness testifies to a certain fact, that proposition A is known to be true. That proposition is within the expert's domain of expertise, not unrelated. And therefore, you have the defeasible conclusion that that fact is probably true. And so what that's going to do is shift that tactical burden to the other side to put up their own expert, or challenge this expert's qualifications, or otherwise challenge their testimony. So what does that challenge look like? If for each of these argument schemes, Walton generated critical questions, which are the sort of arguments that can be used to rebut the argument scheme or challenge the inference. A couple examples relating to expert testimony are to challenge the idea that the person's an expert at all. Maybe they're not really an expert. Maybe they only have a bachelor's degree in the topic, and they've been working in some other field. And then challenging the applicability of the whole domain, whether it even applies in this instance. And then, of course, a common move that lawyers use every day, the trial lawyers use every day to challenge the other side's witnesses is to look for evidence of bias. Of course, expert witnesses are paid to testify. They're paid to help. They're paid to come to a certain conclusion. And of course, that's just an old standard. Of course, you can always, on cross-examining the other side's expert, make hay of the fact that, that perhaps they're just saying this because they were paid to. Argument schemes can be thought of as a way to identify legal reasons supporting your conclusion. And there are other ways to identify legal reasons as well. So, for example, you need to go find helpful rules. This is what most legal research projects and assignments amount to. Trying to find the source material from which you can synthesize rules that are correct, will be persuasive to a judge, and intersect with your facts and lead to the conclusion that you want. A big part of that is understanding the hierarchy of authority and then learning how to argue effectively based on those precedents. And that's something that I devote a whole chapter to, chapter 8 in Elegant Legal Writing. Then there's this idea of argument moves. And I note a couple of books there that primarily teach argument moves, among other things. But I'm a big fan of Ross Kaboom's book, Point Made. Read it countless times. I've taught it. And he's been a great mentor for me. as I've kind of broken into this field myself. But point made, this is a simple example of an argument move taught at the beginning of point made, is this idea of one fell swoop. So you distinguish a bunch of the opponent's cases at once by finding a common distinguishing factor. That's what I call an argument move. There's also another one by a professor of legal writing at Yale named Messing, and his book is The Art of Advocacy. Both of those books are strong because, like elegant legal writing, they teach by example and showing these techniques in action. So highly recommended. Then you have interpretation techniques whenever interpretation issues are afoot, which is true more often than not in the law. So interpreting statutes, interpreting contracts, and so on. And the best book on that I'm aware of is Garner and Scalia's book, Reading Law. And then as far as policy and value-based arguments, there's a phenomenal book by Ward Farnsworth of the University of Texas School of Law called The Legal Analyst. This book, I think, turbocharged my skills as a 1L when I read it before my 1L year. It just shows some brilliant ways to integrate thinking about economics and philosophy and other disciplines into and how they operate in legal problems. I want to say one thing about policy arguments too, which is that if you can take the policy argument and instead of treating it as kind of like frosting on the cake, if you can argue correctly that it's part of the rule itself, it's not extraneous, then it's going to be much stronger. And then there are other sources as well. Ideas of classification. How a lot of legal reasoning involves classifying something as one thing versus another. You see this a lot in property law, for example, when you talk about easements. Concepts relating to vagueness. So thinking about what's the appropriate level of generality at which a rule should be discussed. What are the edge cases? Logical fallacies. Rhetoric and persuasive techniques. These are really not going to function as reasons most of the time. However, they kind of can. Like, for example, the rhetorical concept of ethos has to do with your credibility as a speaker and writer and persuader. So it can actually function as kind of an implicit reason backing your arguments. If the court comes to believe that you're going to not get them reversed if they rule for you, because they've come to trust that you are an excellent researcher and an honest advocate who makes sound, not just convenient legal arguments, but sound ones, that can function as an implicit reason for the judge to rule in your favor. Cognitive biases. So best example of this would be using a technique of anchoring, for example, in a mediation to function kind of as a subconscious reason for the other side to settle at a value you find acceptable. And then legal history. So when you make originalist arguments about what a term of art meant at a certain time a statute was enacted, or you talk about how the common law approached a particular problem, and it's been done this way for hundreds of years. So when the other side tells you it's some other way, they're wrong. These are all potential sources from which you can craft good arguments and good based on legally cognizable reasons. And I think almost always the best one is if you have a statute or a contract provision directly on point, often in combination with great cases decided in favor of somebody in your client's position with analogous facts and with the cases being published and binding in the jurisdiction. And I'll note that it's helpful. I find that helpful when I teach, and I think my students find it helpful to have kind of a default go-to template, especially for those times when you only have 3 hours to write a motion or a brief. It's sometimes helpful to go in from the beginning with kind of a framework of how to organize it. So what I teach is these frameworks. For point headings, your good default point heading in an argument section will be conclusion plus your best reason, linked by a because statement. And I talk about this in the book. And then for argument sections and subsections, more broadly, they'll start with a conclusion, provide your best reason, and then your second best, and then your third, and then finally rebut the opponent's arguments. They'll vary these to each particular brief, but that's the that's my standard way of doing it. Sometimes an opponent's argument may be sufficiently potentially convincing to a judge that you'll need to rebut it front and center. It has to be adjusted on case by case. So I'm going to take a look at the questions here momentarily, but that concludes the presentation portion of my talk. My book is available. It's affordable. We were able to keep the price down from the University of California Press. So it's a bit, and it's also they were generous enough to be able to license the audio rights, so it's on Audible as well as Kindle and print. And my blog is elegantlegalwriting.com. It's periodically updated, not really when I'm in a trial month, but you'll see if you follow that blog, you're going to see a new material. I don't really very often recycle anything. It's often I get bored by talking about the same things, so you'll increasingly see little drafts I'm testing out from my new research about legal reasoning and so on, as well as new examples of writing principles. I use LinkedIn now. I've been able to become part of this great community of legal writing aficionados and lawyers on LinkedIn. So I would recommend following my account there if you'd like to see what I have to say about legal writing. And my law firm is open for business. We're a business litigation boutique, and I do legal consulting through the law firm, represent clients, both plaintiffs and defendants, and we have a transactional side as well. And then I also do private workshops and speaking engagements for those interested. So with that said, I'll take a look at the questions.
Wonderful. Thank you so much, Ryan. We will move on to audience questions as he said. So if you have any questions for him, looks like we've already got a few we can dive into. But just a reminder, if you'd like to submit them, please feel free to do so by clicking the Q&A button in the control panel at the bottom of your screen and submitting there. All right. You want to go ahead and get started, Ryan?
Absolutely. Okay. The first question is I'll summarize as being that can conclusory statements helpfully function as introductions? And I think that can be true to a point. It's just that the reason I recommend a point heading being conclusion plus best reason rather than just the conclusion is that it can foreshadow where you're going and prime the reader to start thinking about that best reason. Oftentimes it will be kind of self-evident from the motion or the brief, what's on the cover page, what you're going to get at as far as broad conclusions. If it's a motion for summary judgment or a motion to dismiss, let's take that example, then you're aiming to the broad conclusion that the plaintiff's complaint, even taken as true, doesn't state a claim. So if you just formulate it at that high level of generality, that could work as an introduction, but it's not as strong, in my opinion, as previewing the best reasons. Now, that said, you can start with a broader, it's perfectly acceptable to start at a higher level of generality and work your way down. I just think it's helpful also to foreshadow what your best reason is. The next question was, can I say more about why I don't like IRAC? Sure. So the first is that it doesn't help you answer the question of fighting about the legal premises or the fact premises. And that's kind of where most of the action happens in contested motions. It's also sometimes can turn into kind of formulaic prose that just kind of plods and doesn't. It can kind of actually encourage conclusory writing because of the fact that it doesn't tell you how to support premises. As far as a writing structure, starting with an issue to me doesn't make a lot of sense because the issue is always going to be whether a certain conclusion is correct. So the issue can be, the issue can always be just stated as the conclusion or inferable from the conclusion. And then as for CREAC, which I think is taught more commonly these days in law school, I don't follow why you would need to say the conclusion both at the beginning and the end. I don't think you want to just trail off, as I say in the book, but the reader shouldn't lose the thread of your argument and what you're aiming at by the time you get done with that particular argument. It should still be in their head. And if it's not, then you probably have a bigger organizational problem or need to condense the argument so that they don't forget what you're talking about. Also, the other thing about CREAC is that the E in the middle, the rule explanation, it tends to lead to one of the biggest, most common flaws I see in legal writing, which is overemphasis on rule statements and overlong rule statements. I've seen oppositions to motions to dismiss, for example, where because because it's hard to satisfy the standard for the defendant, you'll find the plaintiff going on for 3 pages about the 12b6 standard, even though every federal judge has mastery of those rules, and the rules by itself don't tell you whether this particular motion meets the standard. So it kind of conclusorily implies that because the standard is difficult, then surely this defendant hasn't met it. That kind of just postpones the argument. So that's why I don't like the E in the middle of CREAC, because I think that simple rules or straightforward rules don't need to be explained. They can often just be asserted and backed by, one citation, and the explanations become necessary if it's contested and the contest is strong. Okay, strategies for organizing and prioritizing the rules most relevant to your case. We think in my litigation practice, we think about trial and, what's going to go on those verdict forms and jury instructions from day one. What are the elements of a claim? If a claim's elements are at a high level of generality, then you're going to dig in and find, add a little bit more meat to them by figuring out not just that you have to prove lack of good faith, but what kind of factors have courts considered in saying that there's good faith or not in a certain context. And once you identify what the kind of rule conditions are that lead to the outcome you're looking for, what needs to be proved to get there, then you want to find backing for each of the rule conditions. And you're going to find factual backing from discovery and legal backing from legal research. So you're just working backward from what you'll eventually have to prove on the assumption that the case is going to be tried and end up with a jury in a room looking at a verdict form. Estimate on when the new book will be published. I have a 1-year-old daughter and a thriving trial practice, and I'm promoting the book that came out in February. So don't hold your breath. It's going to be a while. But that said, I'll be, the reason, for example, that I picked this topic for today's webinar is to force myself to move it forward. And I'm going to continue doing that. So if you follow me on the blog and social media, you'll see it coming out in dribs and drabs. But the next book itself, hopefully will be released, in the next few years. As far as the next question, which was, how do you weigh the persuasive and authoritative value of legal authority? So I would point you to my book, Chapter 8, which is called Using Legal Authority, which includes a section on the hierarchy of authority where I propose a ranking. But you can't get around statutes, contracts, the Constitution. Oftentimes those will need to be augmented by interpretation rules of some kind. But once the ordinary meaning of them has been determined, it's hard to get around them. But then, assuming that you're not dealing with an interpretation issue like that, then your best bet, it will always be in jurisdiction cases that are judicial opinions that are published, that remain good law, haven't been superseded, that are decided in a similar procedural context to the current motion, and that have similar analogous facts, are not easily distinguished, and that the motion ends with a ruling in your client's favor. Always check that last part, because it's always fun when the other side cites a case and relies on a case, and what it turns out is that they're relying on dicta, and then when you go read the case, which you should always do, you find out that actually your side won. So now you can go ahead and appropriate that case for your own argument. It's a no more reason to read the cases and not, delegate completely to somebody junior, or to, God forbid, an AI program. These things can only be starting points for your research, not the end of it. And reading cases is an underappreciated art, just like reading in general. There was a question about speaking indictments as they relate to filing of a complaint in civil practice. I think I'm going to interpret that as talking as potentially meaning how detailed should factual allegations be in a complaint. The modern trend, as led by the Supreme Court of the United States, and visible in particular in the Twombly case, followed by the Iqbal case, for dealing with adequacy of pleading under Federal Rules of Civil Procedure 8A, is that you have to allege more evidentiary facts, more facts that are, that are intelligible and not just bare conclusions, and that they have to be plausible. That's the modern trend, and it fits well with my own philosophy of writing complaints and writing legal documents in general, which is to make them interesting to read. So take the salient evidence, put it front and center for the court right in your complaint. So our complaints will go into much more greater detail than is typical. And we'll take some of our best evidence and we'll put it right there in a screenshot or right in the complaint. My law firm is lead counsel, for example, in a class action against the makers of Stanley Cups up in Seattle, and we have it's a false advertising case or deceptive advertising case. So we have a QR code that leads to an Instagram, to an Instagram influencer doing an advertisement that we say is deceptive. And we routinely use visual aids of that kind in our filings. So I do believe in generally including more factual detail in your complaint so you could tell a coherent story right from the beginning. Other than my book, what are the legal writing and reasoning books that I most highly recommend? The ones that I mentioned in my slide, I would say on the legal reasoning side, I haven't found a go-to book on legal reasoning that I think is that is I can sort of wholeheartedly recommend as the answer on that one. Probably the closest, but it's a little bit abstract, is a book called How to Do Things with Legal Doctrine that somebody on LinkedIn pointed me to earlier this year. But as far as legal writing, I have a recommended reading list at the back of Elegant Legal Writing. I've been heavily influenced by Gruberman, also by Brian Gardner. Some of what's in Elegant Legal Writing is synthesizing past work done by them, by others, and I also draw on ideas from cognitive science and also prose style books from outside the law, the sort of thing that you'd read in a book about how to write fiction or how to write poetry, for example. So I talk about rhythm, emphasis, things like that. Some of the particular books I'd recommend, I mentioned The Art of Advocacy and Point Made. And I like Garner's book, The Winning Brief, Modern English Usage. I like the Red Book. And there are some others as well. But I take a look at the recommended reading in Elegant Legal Writing. And what tips? So another question is, what tips do I have to make your briefs more lively on the page? And I just provided a couple with visual aids as being an example. Choosing salient facts and salient evidence, removing extraneous details is crucial. Being concise, and then the fiction writing or literary writing concept of pace is helpful to keep in mind. So if you think about the devices used by popular writers, short paragraphs, a sense of suspense, these things can be borrowed by legal writers as well to just kind of write in a way that is within the norms of the profession, but not necessarily boring. Nobody said it had to be boring, just because most are. So I take a look at my at Elegant Legal Writing, and in particular their chapter, I think 9, which is called Legal Storytelling. That's about how that brings in some of those techniques about how to write compelling narratives. What do you do when a court indicates it wants to change the rules? This isn't, and then example being the Supreme Court. It's just not really a situation too often encountered in practice by litigators. You usually have to convince the judge or panel of judges on appeal that the outcome you want is mandated by the current set of rules. If you're in a position of having to argue for a change, the most fruitful situation when that's happening is when you're a part of a legal advocacy group, like I don't know, the ACLU or the Institute for Justice or Center for Reproductive Rights, whoever it may be, Lambda Legal. They have the flexibility to kind of bring impact litigation to try to move the law in a certain direction. But for those of us doing day-to-day civil litigation, the rule always is going to have to be that you're going to apply is not overturn your peer court, a different panel, not overturn the Supreme Court, not change the law, because that's just a guaranteed way to lose the motion. And if you win, it'll be a Pyrrhic victory because it'll eventually likely get overturned if it's clear that that's what the judge did. So find a way to formulate your outcome you want and the rule you want within the current set of available rules whenever possible. And if you can't, then settle the case. Where can people see examples of my legal writing other than the book? So I do have examples of Ryan McCarl LLP's writing, and I believe. Let me just test it real quick. But I do have. I will. You know what? I'll probably just pay. I'll put. I'll pay. I'll test the link and I'll put it on LinkedIn after this meeting. So if you check my LinkedIn page, you'll see a link to a Dropbox folder that contains examples of our firm's legal writing. And none of it's not perfect because the fact that, like as I discussed in the book, your priority as a litigator is to get it done on time, follow the rules, and then kind of work down from there. But you're not creating specimens of perfection. But that said, I am proud of the way we do our filings, and that's why I'm willing to put them out there for people to see as examples. Yeah. Somebody asks, is it fair to summarize the advice about conclusory statements as a statement is non-conclusory and acceptable if it both states a legal conclusion and states the key factor facts that will be used to support the conclusion? I think that's right. As long as, but I did mention, however, that merely juxtaposing the rule and facts is usually not sufficient. You have to usually have to show that the facts fall within the rule, which may require something more than just putting them side by side. Putting them side by side works if it's the speed limit violation example, but in a complicated case like the securities fraud example I provided, you may need to synthesize the rule, characterize the rule accurately, but and based on sound authority, but in a way that encompasses the facts, and then characterize the facts in a way that they fall within the rule. And those all might need to be defended. Judges whose opinions I recommend as models of good reasoning, I would say Judge Easterbrook of the Seventh Circuit is the first that comes to mind. He taught my top academic experience in law school at the University of Chicago Law School was taking a legal interpretation seminar taught by Judge Easterbrook, and really a career-changing event for me in a way. I mean, he's a brilliant writer and his reasoning is brilliant. So to me, he's kind of at the top of the profession in some ways. I think Justice Kagan on the Supreme Court might be another example. Justice Roberts in cases that I agree with him. And which is not always, maybe not even most of the time, but when he's right, he tends to make very good arguments in favor of his position. That's why he features quite a bit in Guberman's book, Point Made, for example. But Easterbrook, I would say, would be my go-to, both for writing style and reasoning. And he also taught me the importance of typography, which ultimately planted a seed. And the last chapter of Elegant Legal Writing is about legal document design, how to use which fonts to pick, leaving Times New Roman behind, moving on to Palatino Linotype or Century School Book, having wider margins, these kind of things, because judges, they're reading thousands of pages a day or a week, and why not make it easy on their eyes? That's all I have for today. So I appreciate everyone's time, and I guess there's one last question, which is, can the sample writings be made available by email rather than on LinkedIn? I can put them in my blog. I'm not gonna. I can't. I'm hundreds of emails behind, unfortunately, so I can't promise to respond to an email. I encourage people to email me if they wish. I just can't promise to be able to respond promptly. But I can put it on the blog, and I'll put it on LinkedIn as well. So I really appreciate everyone's time. I hope that that you found this helpful, and I hope you'll continue the conversation with me and take a look at my book and get in touch if you'd like to.
Wonderful. Thank you so much, Ryan, for answering all of our audience's questions. And thank you all for sending in your questions. We want to thank you for joining us for another Justia webinar. As I mentioned at the top of the presentation today, I want to remind you all of the website services that are available to you through our website platform, Justia Elevate. Justia Elevate is our groundbreaking WordPress-based platform designed and customized specifically for lawyers and law firms. It offers a wide range of features, and as today's presentation focuses on legal writing, I did want to highlight our Justia AI Writer. The Justia AI Writer is designed specifically to help you create law firm website content and intuitively draft high-quality legal content that focuses on various practice areas and related legal topics. You can utilize that to power up your legal content writing and boost your Justia Elevate SEO. If you'd like to learn more, please visit us at elevate.justia.com and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.